talking, I don't sweat that. If they don't trust me either, I respect that. But she need down the ride, oh, I bet that. Ooh, I slide for my people, don't forget that. Don't forget that. Don't forget that. Ooh, I slide for my people, don't forget that. Don't forget that. Don't forget that. Ooh, I slide for my people, don't forget that.
So let's get straight to the point. There's no good mornings, no good afternoons, and no good evenings. USPS wants everyone to know its policy on firearms on postal property. Employee safety is a top priority for the organization. Before you shut it off, because you hear bullshit coming out of my mouth, I'm just reading what they wrote. Employee safety is a top priority for the United States Postal Service, which is why the organization wants to ensure everyone is aware of a long-standing policy on firearms on postal property. A recent Florida District Court decision is being misreported or may be misinterpreted as holding that the Postal Service's ban on carrying firearms either openly or concealed or storing them USPS property is unconstitutional. In fact, the case dealt with a different federal statute and does not involve the Postal Service regulations. Therefore, it does not change the organization's policy. So I'm going to dissect that for you real quick before we move past it. They never said it's unconstitutional. That is not. They didn't say that. What they're doing is playing words right now, but we're going to get into it. And then they quickly move on to the next note. Employees are reminded that carrying or storing firearms or dangerous other deadly weapons or explosives either openly or concealed on U.S. property is prohibited and can result in discipline, including removal from the Postal Service as well as potential prosecution. And they can't prosecute you because it's clearly against the law. This prohibition includes storing firearms in vehicles that are parked on postal property. That's another one right there. And that was it. That's it. So again, they missed the whole point behind it. But Jay's not a scholar in this. I do have a clip coming up for you guys so you can hear exactly what they mean by this. But never once did the post office say, no, we are not infringing on your constitutional rights, because they can't say that, because then they'd be held liable. They're saying it's their policy. They're not saying that their policy does not violate your Second Amendment rights. Now, excuse me for a second. For those that don't think that Jay is a Second Amendment right type of guy, when I drink my coffee, think about that. When I drink my coffee, this is what happens. Yeah. Okay. So let's not even go there with some of that silliness. But I get it. They don't want to open up Pandora's box because they realize there's a lot of screwy shit that goes on behind the scenes, and they don't want to put themselves in that position because honestly, there's a bunch of crazy postal workers. But in fact, the case was dealt on a legal basis on a criminal case, and it applied to the one person. But it did open up a can of worms because that person did win. Now it has to go through a civil situation, which the National Rifle Association, NRA, they're going to fight it. But again, just so you can hear, and I'm going to play something so you guys can hear it a little bit better in layman terms from another creator, and I'll leave the link to his videos down there. You get all credit for it. It says that the decision is being misreported or maybe misinterpreted as holding that the Postal Service's ban on carrying firearms, either openly or concealed or storing them on U.S. property, is unconstitutional, right? They're saying is being misreported. Their answer to that, in fact, the case dealt with a different federal statute and does not involve the Postal Service's regulation. Therefore, it does not change the organization's policy. It never once did it say it's unconstitutional. It's their policy. So if they decide, the post office decides that it is our policy that from here on out, only women can work on the west end of the building and men can work on the east side of the building and gays can work in the back of the building and midgets can work on the front of it, then they could use that and say, that's our policy. Even though it's unconstitutional to segregate, but that's our policy. That's what we want. They can get away with it. Nobody above the law. Nobody's above the law. Now, again, unfortunately, they technically have it correct for now. But you can guarantee this opened up a can of worms for the NRA to go in there and start drilling away at it because it is unconstitutional and the post office is not saying it isn't. They're just saying our policy says no. F your constitutional rights. I ain't trying to stir nothing up because I'm not bringing one to work. I ain't chancing it. But let's hear what this man has to say. This is a conversation piece, and you can hear I'm truly passionate about this.
All right, folks. A few days ago, Judge Catherine Kimball Mazel of the Middle District of Florida has issued a very important Second Amendment ruling on quote-unquote sensitive places. As you know, sensitive places is a euphemism for government-mandated gun-free zones. In the case of the United States versus Emmanuel Ayala, I think I'm pronouncing this, I think it's Ayala, Ayala. In this case, a postal worker was indicted for having a firearm, a regular handgun, I believe, at the post office, and he was indicted under federal gun control statute 18 U.S.C. 930A on the grounds that he had a gun at a post office, and this was allegedly a no-go. The defense attorneys filed a motion to dismiss the indictment on the grounds that the federal statute violated the Second Amendment's right to keep and bear arms under the standard of Heller and Bruin. I'm happy to report that Judge Mizell has held that the government, the United States government, the Department of Justice under Joe Biden and Merrick Garland has failed to meet its burden under the Bruin test to show a historical tradition of carry restrictions in United States post offices and therefore dismiss the charge. Just to jog your memory, under the Heller/Bruin test, once the text of the Second Amendment is implicated by a gun control statute today in the 21st century, the burden shifts to the government to justify it on historical grounds. The presumption is that if the text is implicated, the presumption is that the law is unconstitutional under the Second Amendment. Obviously, the text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed, preventing an American citizen who is part of the people from being able to bear," which means to carry, a handgun on federal property. Obviously implicates the right of the people to keep and bear arms because you're banning a member of the people from being able to bear, i.e. carry guns in a particular place. So the text is implicated, the burden shifts to the government, as the law is presumptively unconstitutional, 18 U.S.C. 930A. And then what happens is the government can come forth with historical analog laws. They have to be actual laws from the time of our founding in 1791, whether it be common law, whether it be state statutes, whether it be state constitutional rights or state constitutional powers, whatever, or the federal constitution, whatever, but some actual law enforceable. It cannot be airy-fairy history of some historian from Harvard saying, hey, here's my view of history in the 18th century. No, the burden is on the government to come forth and say, here is a law that was on the books. And this law was ubiquitous. It was well established in a long-standing tradition in the United States from the 18th century through the 21st to justify that restriction on Second Amendment rights, if you will. Now, I'm happy to report that the judge specifically said that there's no way the government could possibly meet this burden, and we'll get into those defenses in 1 second. But before I get into the specific arguments that the government raised and why they were rejected, and rightly so, and then I will give you a couple thoughts about how I think that the opinion could have been improved upon by this very prominent young judge. What I want to say before, first and foremost, is to answer one question I've already seen quite a bit on X or Twitter, and that is, what does this law mean for other people in the state of Florida and across the country that go to the post office? The answer is, this decision right now only applies to the specific criminal defendant, Emmanuel Ayala, in this case because he was indicted and he moved to dismiss the indictment, and that indictment has been dismissed. So it applies to him, but this is different. This is a criminal case that only is dealing with his rights and his situation, his freedoms. It is not like a civil case where, let's say, the Second Amendment Foundation, the National Association of Gun Rights, the Firearms Policy Coalition, the NRA, brings a lawsuit, civil lawsuit to challenge the gun control regulation on the grounds to get it enjoined with a permanent injunction as declared unconstitutional under the Second Amendment. So therefore, there is no injunction in place in the federal system or even in Florida for that matter saying that this law is unconstitutional. So,
unexpected expenses stressing you out? Get the money you need now with Loans for Feds, a program designed specifically for federal employees. Bad credit is not a problem. Application is fast and easy with same-day approvals. Apply now.